If you inherit a property in California, it's usually going to fall into one of two categories. Either it's held in a trust or it has to go through probate. And, well, you're probably going to hope it's one and not the other. But we'll get into that. Let's break down the differences between a trust sale and a probate sale and what each one means if you're planning to sell or buy a home that's part of an estate. Let's start with the smoother one, a trust sale. If the property was held in a living trust, then the trustee or successor trustee has the authority to sell the home without going through the court system. They can list the property, review offers, and close the deal just like any standard home sale. In most cases, it wraps up in about 30 days. That's because trust sales happen outside the court system. No hearings, no judges, and no delays. Now, even though it's more straightforward, there are still disclosure requirements. A trustee may have to make normal disclosures about the condition of the home, but if a trustee passed away and a successor trustee is appointed who has never lived in the property, they will not have to provide traditional disclosures and will usually just fill out what's called the exempt seller disclosure. Now let's talk about probate. If there's no trust or the trust didn't include the property, the estate usually has to go through probate court. The court appoints someone to handle the estate. That's the executor if there was a will, or an administrator if there wasn't a will. That person becomes the seller of the home. Now, here's where things get a little bit more technical. In California, that personal representative might have what's called full authority under the Independent Administration of Estates Act, or IAEA. If they do, they can sell the property without going to court as long as they notify interested parties first. That makes for a much easier process. And that's done through something called a notice of proposed action. If no one objects, then they can move forward with the sale. If they only have limited authority, though, a court hearing is required to approve the sale, and that can take some time. Now, depending on the county, you might wait 6 to 12 weeks for a confirmation hearing after an initial offer is accepted. And even then, the accepted buyer could be outbid in a type of auction that takes place at the court, and it can get pretty exciting. Now, there's a formula for this. The first overbid amount has to be at least 5% plus $500 more than the accepted offer. So, if $1 million is the initial accepted offer, the first overbid would have to be $1,050,500. Then it can go up in amounts set by the judge, and that's where things can get wild. So, if you're the buyer or representing one, that's something you'll definitely want to be prepared for. Ready for a crazy fact? Many famous people have died without a trust or a will, like Prince, Aretha Franklin, Pablo Picasso, and even Howard Hughes did not have a valid will when he passed away. Now, let's talk about paperwork. Probate sales use the probate purchase agreement and a probate-specific addendum, usually called the PAPA form. Trust sales use the normal residential purchase agreement with a trust advisory and the exempt seller disclosure attached to it. Also worth noting, if you're listing a probate property, there are some timelines in how long it can be listed. The initial agreement can't go longer than 90 days, and the total listing period can't exceed 270 days unless the court gives you more time. So here's the bottom line. If the home is in a trust, you're looking at a clean, fairly traditional sale. No courts involved. But if it has to go through probate, you might be looking at a slower, more complicated process that involves legal steps, notices, and possibly court hearings. If you're not sure which category your situation falls into, or if you're looking at buying a home that's part of an estate, let's talk. I'll help you navigate the process and make sure everything goes as smoothly as possible.